Hello, everybody, and welcome to the second episode of the Surrogacy Space. My name is Marla Neufeld. I'm an attorney at Greenspoon Marder, and I'm the chair of the Third-Party Assisted Reproductive Technology Practice Group. So I handle everything pertaining to surrogacy, egg donation, sperm donation, embryo donation, and anything related to third-party reproductive technology. And I'm super excited to have my colleague and fellow partner here with me today, Alan Cohn, one of our trust and estates partners. Welcome, Alan, to the show.
Glad to be here, Marla. Thank you.
Yeah, and you have the honor of being my very first guest on the Surrogacy Space podcast. So I'm very honored for you to join us
Well,
today.
I'm honored to be here. I will tell you that I am old enough that assisted reproductive technology was not an area of law when I graduated law school. So I am excited to be on this podcast.
But I think that I might have sufficiently roped you into this area of law, being that you help so many of my clients with their estate plans, which is an important thing that we're going to talk about today.
It does change the dynamics of estate plans, which we will talk about. There was a time when our grandparents or great grandparents, they probably had their children like in their late teens or early 20s, and then it was in the 30s, and now with what you do for a living, it can be almost any time.
I do represent clients of all ages, genders, genetic makeups, and it really has expanded the way to build your family. So, what I'd like to talk about today, being that we're going to focus on not necessarily the legal components that go into surrogacy and third-party reproduction, but other really, recommended documentation that should be in place. I mean, who would think that so much paperwork would be needed to have a baby? But in what we do, there is. I'd love to know a little bit about your practice area and just kind of, where you went to school, how long you've practiced trust and estates, just a little bit about you as an attorney.
Well, I went to a law school, and I have a degree called an LLM, which is a master's in taxation law, tax law, both from the University of Florida in Gainesville. I have been practicing for blah 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 years. That was 10, purposely muted that there, but it's been quite a while now. I am predominantly in the trust and estates area. You don't necessarily need to have a tax degree to do trust and estates law because not everyone has a taxable estate, but there are a lot of people that do, and there's also a lot of people that don't, that I handle all the issues that come with it. And also, if you have minor children, there are things that, or even young children aren't minors, there are certain things you would want in your estate plan that I do for quite a number of people. And those types of things are obviously critical to the surrogacy, that area of law when people are having children, no matter how they have the children. I
Right.
also, I again, I enjoy what I'm doing. I've been doing, like I say, I've been doing trust and estates law. I also do some other areas of tax law. I do some corporate and things like that, but the
Okay.
predominant wills, trust and estates.
Is your tax background something that comes into play in representing high net worth individuals? Does that
It, it
expand who you're able to assist?
it does, because I mean, when people have assets, I mean, a lot of times people come to me and they say, I'm not rich," and maybe they don't feel rich. I mean, it's a but if they died and they liquidated their home and collected all their life insurance and sold their business was sold and everything like that, it actually adds up to a lot more than you think it is, even though you may not
Right.
feel you have a taxable state. And then, of course, there's people that have highly appreciated assets, and when you sell high appreciated assets, there's capital gains, and
Right.
there's we can do to make sure we minimize those also. So those are some of the things that we do. Florida, in particular, where I practice most of the time, where I practice is not doesn't have a state inheritance, but I also do deal with people who have property in other states that do have state inheritance taxes, or other
Okay.
countries, and those become an issue, obviously, in their estate plan also.
Well, that leads to my next question. And as you know, I represent intended parents and intended parent, really from all over, not just the country, but the world. So, in your opinion, where should a client go to for their trust in a state's attorney? Like, as far as the state law that would apply, like what brings them to Florida or any other state?
Well, it needs to be predominantly where they're domiciled. And now that's a tough word because people say, oh, I'm not, I could say I'm domiciled in Montana, but just because I spent 2 weeks there in a year doesn't mean I'm a domiciliary of Montana. So
Right.
it's a factor test, and that's how states and look at it to determine where they think people reside. Obviously, intent is important. I intend to be here.
Right.
But you look at other things like, where are your cars titled? Where do you vote? Do you file for homestead exemption? Things like that. And that's how you determine where you're domiciled. So predominantly it should be where you're domiciled. Now, if people have property in other countries, then I might suggest a will for that asset in that country, because if you had a Florida will and then you died and you had property in another country, particularly if it's a
Right.
non-English country, you'd have to get a translation of it and the whole bit. So sometimes
Hmm.
I do recommend state plans, small wills or something in places where they might have substantial assets, but generally it's where you're domiciled.
Okay. And that would go for if the parents are international as well. Like if they reside in
Hmm?
Spain or France, it would be recommended that they speak to an estate planning attorney in their home
Correct.
country.
Correct. But again, let's say they live in Spain or France, but they have U.S. assets.
Okay.
Do a U.S. document for the U.S. situs assets, and situs means where the asset is located. Like a piece of real estate is considered situated where the land sits, as an example.
Okay. No, it's super helpful because, as we know, people come from all over to Florida to build their family through surrogacy. And I think it'd be great to take just a baby step back, so to speak. And if you could just give us a little overview of what is an estate plan, like what are kind of the basic documents, and we'll start with that question.
So and typically, since we're on a surrogacy call, let's say it's a family, a young family with some kids, kid, 1, 2, 3 kids, doesn't matter. A basic estate plan would be a couple of wills for the parents of the children. You would want to have maybe a power of attorney. If God forbid, if I'm incapacitated, something happens to me and someone has to pay my bills, who's going to pay it? Usually you
Mhm.
would need up for that person. A healthcare surrogate, some people call it a healthcare proxy. It's like a medical power of attorney. It would somebody, if I can't make a personal decision, speak, who's going to speak to the doctor for me? Who's going to hire the nurse for me? For that for the parents, maybe a living will. Some people I feel very strongly that if they're terminally ill and they're vegetative, they don't want to be kept alive on a machine. They
Right.
might want to. And particularly in the surrogacy area, you'd need a nominating guardian. That would be important. I can incorporate that into a will if they had a will, or if they didn't have a will for some reason, I could incorporate that as a freestanding document. But they should have a provision in there, a good nomination that says, if I'm ever something happens to me and my child is still a minor, who I want to raise my child, who's going to raise them,
Right.
and in the wills, I would also have most likely trusts for the children, because under the law in Florida, you're an adult at 18. Very few of my clients would, even if they're good kids and smart kids,
Hmm.
want their kids to get all their money at 18 years old.
Right.
Um, so we would create trusts for the kids, and I would go through them as to who's going to handle the trust for the kids, and at what ages can the children get their money.
Yeah, I think this is obviously a very important thing for anyone building a family, and especially in the surrogacy context, because at the end of the day, I mean, the surrogate is not going to be the legal parent of the child. So if something happens to the parent or the parents, it's very important that they set out their intent within a nomination of guardian of who will care for the baby. I'm curious, like, what would happen if they didn't establish a guardian and something, God forbid, happened to the parents while their surrogate is pregnant?
Well, if something happened to them, someone would run into court. A judge would appoint a guardian. I mean, if you have a minor child and you need a guardian, you're going to get one appointed. But the parents' decision making in this, no, they didn't express it. They didn't say, I
Mhm.
want a person to be my guardian. So ultimately, you could have a situation, and I actually have had this situation over the years. They didn't come to me to draft the documents. So there were no
Right.
documents, and what happened was there were two sides of the family, and they both wanted to be the guardian for the kid,
Yeah.
and fighting over it. And ultimately, the judge had to make a call, and
Mhm.
may not have been the call that the parents wanted, but it was the call because they didn't express what they wanted in a document. And these documents, like a nomination guardian document, it's a pretty straightforward document. It's like 2 pages.
Right.
It's not
Right.
a complicated thing. But without it, you're leaving it up to somebody, some stranger, usually a judge, doesn't know you, to make the decision for you.
Yeah, I
And
mean, we think these things will never happen, but of course they can, and it's a reality. You see it in your work, and you and I have seen it together, unfortunately, on cases where things have happened to intended parents. And with surrogacy, that baby will still be born. I mean, it doesn't change. It's different from a gestating mother versus a surrogate, where the baby will be here.
Marla and I had this situation. We had a thing. I had done the nomination of guardian, and the intended father. He was single father. Did happen to him. He nominated. And it's a good thing he nominated it because there was a family member that wanted to be the guardian, that tried to fight it, but he did express his wishes, and eventually we got it done. And we had to go through a few extra steps because in that case the surrogate was not in Florida. So
Right.
when the baby was born, it was being born, and there was nobody up. There was no longer a father, a natural parent of this child. So we actually had to have a guardian appointed up there to be able to take the child out of the hospital. Otherwise, they wouldn't have just turned the kid over to anybody. Okay, so
Right.
that's something that happened. But they did. But the good news is the documents were in place, so at least the intent of the father that passed was eventually upheld, and that's who's the current guardian of this child.
Right. Yeah, I mean, this is important for anyone having children, not just through surrogacy. I mean, surrogacy adds another layer of why it's so important, but for really anybody creating an estate plan, as far as like people creating a family, when is the best time to have their documents in place with you?
I think they should have their documents in place right at the beginning when they. I mean, so they should have an estate plan even before they have children. But once they have
Yeah.
children,
Right.
they're going to want trust. Maybe they didn't have trust they didn't have kids. They didn't put trust in there for the kids. They didn't have a guardian provision because there was no kid to be a guardian for. So they, even that they have a document and it's old, they need it changed, because if they don't change it, let's say they had a document that just said, I leave it to each other, and if we're both not alive, we leave it to my sister and my wife's sister. Okay, because we didn't have kids. All right. Now
Right.
the good news is, at least in Florida, if if there's a child born and then we both die, even though the child was not named in the will, they would actually be beneficiaries regardless. This is a
Mm.
this is the real legal word that all you people that do Scrabble and talk with crossword puzzles are not going to know this word unless you're a lawyer. The word is pretermitted, and a pretermitted child is one who is born after the date of the will.
Mm.
So be a pretermitted child, even if they weren't named, even if it said it goes to my sister, and they would be included, but I would have to put the money in a guardianship account for them, and they would get all the money at 18, which is most of the time that is not what the clients want when I ask them at ages that their child could get the money. They don't say all of it at 18. Very.
Yeah, I mean, that's an interesting point you raise. You know, people might already have an estate plan, but it might need to be updated. I mean, I know the law changes that might need to update documents. And even the fact that, you know, within our Florida statutes, we have something about posthumously conceived children.
Mhm.
So many people are freezing embryos that can be frozen for a very long time. And if let's just say a couple were to create them together, one of the spouses were to die, and if the other surviving spouse used the embryos, that child cannot inherit from the deceased spouse unless they were contemplated for in their will. So there's
Mhm.
really a lot to think about as far as how they want the family plan to go in their estate package, and the surrogacy world just kind of expands it so much more.
It's been a big area. When I started practicing law, I guess I'm dating myself. I mean, there was no situation where you could have, genetic material that a child could be born, sometime after the person dies. So this is an area that we ask questions about now, that I didn't used to have on my checklist to ask a number of years ago. So
Right.
your area of law, Marla, has really changed a lot about what I do also.
Yeah. And something that I've learned through just experience is we're not even just talking about the parents, the intended parents' estate plan, but you kind of mentioned before talking about grandparents' estate plans. There might have been a generation where they had restrictive language like my genetic heirs or
Mhm.
something that, and now that people have non-genetic children, through donor embryos, it's important to evaluate not just the parents' estate plan, but their grandparents to make sure that their future children won't be disinherited. And I've
Yeah.
seen that have to be
Yeah.
adjusted.
And there are some people that are still, old school, that
Yeah.
I want to recognize children born during marriage, you know,
Mm. Yeah.
uh, or things like that.
Right.
But we do discuss it, because clearly, if you don't discuss it, then it's something that could, even adoption was always an issue,
Yes.
because some people were fine with an adopted child at birth, but some people may not have been okay with a step parent adoption, as an
Yeah,
example.
and that's interesting you raise that point because in Florida, it's really not an adoption. In certain cases, it might kind of you might need to do a step parent, but in some states, it is an adoption. So you would want to make sure that if you actually are having to undergo some form of adoption proceeding, that your estate plan wouldn't exclude your children or your grandparents' wills, things like that.
Correct. Correct.
Yeah. Well, this was so informative, and I think it's such an important thing for really everyone to be aware of the importance of having an estate plan. What would be the best way for a parent to reach out to you to get more information about setting up an estate plan?
Well, unfortunately, I have no life, so I'm always here in the office. So
Yes, you do always respond to my
I,
emails very quickly.
so I tell my wife all the time, as a psychologist, that there's a book. I guess it's got all the psychological disorders, called the DSM. I don't know what they're up to,
Yeah.
whatever they're up to now. And I always tell her that there's going to be a new area of OCD called OCD technology, because I'm not
Mm,
OCD, but I am OCD with technology. Like, if I see,
yes.
50 emails in my box, I have to look at them. I have to clean them out. So I
Understood.
always responding to my emails, even if it's at night sometimes. And
Even when you were sick, I know you're like, I'm out and I'm still responding. So like,
still
it's very much
responding
appreciated.
and I'm in the office, and I'm old school. I like returning my phone calls before the end of the day. So sometimes I'm here late, making sure I return as many calls. Now, sometimes I don't get the people because they're calling. I was in a meeting, and they were calling from work. And so it carries over to the next day, but I always get back to everybody.
Absolutely. Well, what is your email and phone number that people could reach you at?
Easy. It's Alan, Alan dot Cohn, Cohn, no E, at gmlaw, one word, gmlaw.com. And the office number is 954-491-1120. And again, just ask for Alan Cohn.
Wonderful. Well, Alan, thank you so much for joining me at the surrogacy space and for helping so many of my clients with their estate plan. It's very much appreciated. And hopefully we can talk again soon
Well,
on the podcast.
I love the name of your podcast. Sorry, I didn't know that much about podcasts. So I thought the name was going to be, today was going to be called "Are There Probates in the Building?" You
Ah,
know,
yes. We came up with a catchy title to encapsulate everything.
I like it. I like it.
All right. Well, thank you, and tune in for next show.